Greetings from Columbus, Ohio. Pleasure to be here today with the Permanent Peoples Tribunal. My name is Rick Sahli. I'm an attorney. I've been practicing environmental law in Ohio since 1980, so I think that's 38 years. I've been in my own private practice since 1995, and I've only represented citizen groups all the way from the smallest grassroots groups, which frankly are most of the fracking activists in Ohio, all the way up to national groups. That's in both state and federal court. My presentation today is going to be in two parts. This will be 1 hour. We break for lunch, and I'll be talking about the two pre-tribunals that we did in Ohio last year, and also discuss the 40-page report that came out of that. Talk about some of the very specific testimony that we received, also some of the unique issues in Ohio and frankly in the United States in general trying to deal with fracking. And I'll try to hold a few questions, time for a few questions at the end of that. And we'll have an hour and a half for lunch. And when we come back, I've individual interviews of some of the witnesses who testified at the tribunal last year. I'll be showing several items from their testimony to give you a sense of what it's truly like day to day in the state of Ohio when it comes to fracking. Hopefully also my discussion will give other groups who are thinking about doing tribunals some background, how to do the report, and how to approach pre-tribunals. So on that score, let me start the formal part of my presentation by saying that these pre-tribunals were very important to the people in Ohio. It was very good for us to do this. And that's because affected by fracking have had very, very few opportunities to get their story out. When fracking started in Ohio in 2011, Ohio was still in the grips of the terrible recession that began in this country in 2008. And our political class, that's always been very close to the oil and gas industry as they were to the coal industry before that, absolutely embraced fracking with a passion as a potential way out to get some new economic development going. To the extent the newspapers have covered the stories at all, they've only covered it in the sense that so much new investments coming in, so many more millions of dollars, and here's the gross numbers on the amount of oil or natural gas that Ohio is now producing due to fracking. Another reason that the people who testified thought it was so important is about a very important aspect of the Ohio fracking story. And that is all of the fracking production wells, quarters of all the fracking wastewater injection wells, is located in eastern and southeastern Ohio, in an area we call Appalachian Ohio. Now, the Appalachian Mountains is a large mountain range in the central part of the eastern United States, covers quite a few states, and historically that mountain range has been a difficult weight on economic development. As a result, Appalachian counties are the poorest, they're the most economically disadvantaged, where all the fracking production is occurring. In Ohio, that's normally in the Utica Shale, although there's also some production out of the Marcellus Shale, which is where the earlier production in Pennsylvania started. So our state government's been controlled by Republicans for most of the last 20 years who are very anti-environmental. And our regulator is an entity called the Ohio Department of Natural Resources, ODNR. They are the exclusive oversight body for the oil and gas industry in Ohio. We have an Ohio EPA, but their authority over oil and gas has been stripped away and given to ODNR. And ODNR is a notorious captive regulator. It has been for 40 years by the coal industry, and it has been for the oil and gas industry almost as long. They're notably hostile to citizens, dependable allies of the oil and gas industry. So when I say that the tribunals were very much welcomed It's because this was the first time so many people had an opportunity to tell their story. And a lot of tears were shed as soon as people got up from the table to testify, because of the relief and the pouring out of the anxiety that they had had for years, not being able to tell what's been happening to them. We had 2 days of testimony. One of them was in Athens County, Ohio. That's in the southeastern part of the state, close to the Ohio River and close to the state of West Virginia. 17 people testified there, including 2 experts, a hydrogeologist, and an attorney. The second tribunal was in the larger city of Youngstown, Ohio. Northeast Ohio, what we call the Rust Belt, was a great steel town that has been on hard times for 30 years since the steel industry pretty much left this country. It's close to the Pennsylvania border, and it's where an additional 12 people testified, including 1 expert geologist. While the majority of people testified about their personal experiences living by fracking operations, both production and also the injection well disposal system, others testified onto the deficiencies of Ohio's public participation process that frankly does next to nothing for the public. So our report spent a lot of time talking about the problems with public participation. There's virtually no advance notice of the hearings. There's no hearings given to the public to speak on these items. And the state is very tight-fisted when it comes to giving up public records about fracking. Now, this testimony was all recorded on video, on the web by the Buckeye Environmental Network. That's an oversight group for grassroots groups across Ohio. It's on the YouTube page and Facebook page of the Buckeye Environmental Network. It's also summarized in our report. The report's available on the PPT website. In addition, we had a panel of what we call jurors listening to the testimony. And the role of the jurors was to ask questions, cross-examine the witnesses, to fill in any gaps in the information chain. And they also made the determination afterwards whether and which human rights in the environment had been violated, shown by the testimony. And they also made a recommendation for action. Our report was published last December, and it's 39 pages long. So let me get into some of the key parts of our report. The introduction had really 2 things that principally focused on. The first, we noticed that a key feature in the fracking story, and not just in Ohio, but in the United States as a whole, is that it's come about at the point in time in our nation's history when American government at all levels, national, oh my God, certainly the state, and also even at the local level, is virtually incapable of effective regulation due to the massive amounts of corporate money that's now funding American political campaigns. I think this is probably pretty well known internationally at this point. But our governments are much, much closer to the corporations that pay for their campaigns than they are to our citizens. But not only is that a fundamental feature of the Ohio fracking story, but the second major factor is that the oil and gas industry in the United States is the only industry that isn't regulated by a comprehensive federal program. All the other industries are regulated, and the federal law supplies a minimum level of safeguards, level of technical requirements, and the minimum level of public participation. That's not the case with oil and gas, not controlled by a federal program, except for a small component of the injection well program. So what we have is the state of Ohio, the people here, being dependent on our industry-friendly legislature, captive state regulator, to give them the only protections they've got. And due to those 2 factors, we close our introduction by making the main point that because of these factors, the question is very forcefully presented in the United States, whether Americans are getting the minimum level of internationally recognized human rights industry. Next, our report went into some background. We wanted this to be a standalone report. We thought if we just had the witnesses testifying out of the blue, that folks couldn't feel grounded in the context of what their lives had come into contact with. So we had a history of Ohio's oil and gas industry. And you may not believe this, but in the 1880s, the state of Ohio was the world's leading oil producer. 1880s. That was when Standard Oil Corporation, that was John Rockefeller's big corporation that later became the Standard Oil Trust. It was founded in Cleveland, Ohio, Ohio's largest city. Then we went into discussions how Ohio's always had a boom and a bust cycle when it comes to oil production and gas production, in which Ohio had three distinct booms, fracking being the fourth. They started in 1884, 1961, and 1978, in which there were investments in oil and gas, a lot of removal of oil and gas, but each of those collapsed within a few years to a bust, what we call an economic bust. The economic floor comes out of the industry. And all the corporations that had come here to exploit our natural resources wound up in massive bankruptcies. And they left thousands of plugged and abandoned wells, thousands of abandoned waste pits that had waste fluids from the oil and gas industry were simply left here, and all the profits were taken out of state. Now, we believe this history leaves a very strong inference to the readers of our report that the current boom in fracking will likely be no different, except that the breadth of potential environmental harm, particularly that from the toxic chemicals involved, greater. Now, Ohio fracking began in 2011. As of last month, the latest numbers, we have 2,338 producing horizontal fracked well. All of these are in the traditionally poor Appalachian counties, the most politically vulnerable counties in our state. And worse than that, they're highly concentrated in just 7 of Ohio's 88 counties. Counties are our political subdivisions, and states divided into 88 of them. In addition to those existing 2,300 some wells currently drilled, the state's already issued an additional 500 permits for wells that simply haven't been drilled yet. The industry is waiting for the price of oil to go back up, which is frankly now starting, at least in this country. And also, Ohio is being crisscrossed by 3 new pipelines, federally regulated pipelines that the state has no say in. And when those pipelines open, we expect a lot of those additional 500 wells to come online. So we're going to have 3,000 horizontally fracked wells now pretty much guaranteed. So our history section then goes into separately about the unique problems Ohio has with the injection disposal wells. I trust you're familiar with injection disposal wells. They take all the highly contaminated wastewater that come back up out of these wells when the injection of fluids ends. They're heavily contaminated with the toxic chemicals involved in the fracking process, and they're simply re-injected back down a mile or more, where theory is that it's going to stay there until the end of time. But between the start of fracking in 2011 and today, the number of these injection wells in Ohio has increased from 144 to 239. The amount of the wastewater disposed in those wells increased by 240%. It's now over 30 million gallons a year that is reported. Now, why this is significant in Ohio is that our neighboring states of Pennsylvania and West Virginia, both of them have extensive, and certainly in Pennsylvania, a very mature fracking industry. Each of them have about 24 injection wells for disposal. meaning that much of their waste is being trucked here for disposal. So we have the phenomenon in Ohio of clusters of injection wells close to the state borders, close to our largest highways, taking an endless number of tanker trucks every day, bringing fracking wastewater, highly toxic fracking wastewater, to these clusters of injection wells. And in Youngstown, that's close to the Pennsylvania border, they have a lot of injection wells. Athens County, which is the leading county in the state for taking injected disposal waste, it doesn't have a single production well in that county. The Utica Shale does not extend that far, but they are the #1 recipient of the wastewater, with much of which comes from West Virginia. So we had one person testify that they spent 24 straight hours in front of their house watching the tanker trucks go by. One went by on the average of 13 minutes all night and all day. Now, a section that I think is particularly useful is the next one, which talks about the history of the regulatory program for oil and gas. And it really builds a story that so much of the testimony supported, which is how these regulators have become hopelessly compromised by the oil and gas industry itself. Ohio's program, oil and gas, started itself in the second of our booms in 1961. This happened in an area about 50 miles north of where I am now in Columbus. And there was a large pool of oil, and just as soon as one of those new oil wells found some oil, immediately 5, 6, 10, 12 additional wells would be drilled within just a couple hundred feet of the first well, sometimes in every backyard of a neighborhood. And yeah, there's pictures from that time showing every backyard in some neighborhoods having wells. So yeah, and they're just stealing the oil from someone else's well. So as a result of that, the legislature adopted spacing regulations. And to enforce those spacing regulations, there had to be a state program. So that's how our state program came together at the behest of the oil and gas industry itself. Now, the industry did allow some language in there that kind of referred to the environmental issues. It didn't talk about so much keeping the oil out of the water or off of the land. It said that you should not waste the resource. That we want to make sure the profits are maximized. So the prohibition is not on pollution, it was on wasting the resource. And that was the only environmental protection in the program. And frankly, it's pretty much still the operative language in our state law today. When our next boom started in the 1970s, this program just had 27 employees for the entire state. And at that time, there were close to 50,000 old wells those 27 people had to oversee. So already it was a terribly under-resourced program. Some of these wells wouldn't be inspected for decades. But with the next boom that started in 1978 was when Ohio had its last environmentally sympathetic governor. He was elected in 1981. And expanded the program by 1986, the height of that boom, to 124 employees. And to the great dismay of the industry, the program then had an enforcement office, specifically with 8 special investigators just to do enforcement cases. It also had 3 dedicated prosecutors to bring cases into court about oil and gas companies violating their requirements. But there was an underlying danger in this expansion. Before, the program had been funded by what we call general revenue funds. That's money from the state income tax, state sales tax. It comes from all Ohioans. When the expansion was done, all that general revenue was taken away. And instead, the expansion was funded by fees on the industry. Permit fees were increased significantly, but also there was, for the first time, a severance tax put on oil. and natural gas. For instance, for every barrel of oil taken out of Ohio, it was a 10-cent, 1/10 of $1 severance tax had to be paid. So from that point on, success of the industry became necessary to fund the program. And the two programs probably from that point on had a serious conflict of interest that led the program to be closer and closer to the industry as a way to ensuring that their salaries would ever be paid. So when the bust in production occurred for the boom that started in 1978, most of the funding for the state program disappeared overnight. At the industry's urging, the legislature did nothing to address this funding shortfall. The staff of 124 in 1986 dropped to just 35 by 2007. The first cut in staffing happened in 1991, just as soon as the first Republican placed our last environmentally sympathetic governor. 1991, a 42% cut in staffing. And that enforcement office I talked about was the first thing cut. It has never been replaced. There hasn't even been an enforcement coordinator position since. And ever since fracking started, not a single case has been referred for prosecution in one of our state courts. And that's after we've had plenty of spills, plenty of fracking fluid spills into waterways. We've had explosions, and none of this has led to either a civil or criminal enforcement type action. In fact, our state does not even publish and publicly release statistics on its enforcement efforts. This was also part of the real estrangement between the people of the state and the oil and gas program. The 1978 boom put a lot of the wells in suburban areas, especially in the politically powerful areas around Cleveland and Akron. A lot of wells showed up in suburban areas. And ODNR, which at that time had just 14 inspectors through most of that period, was not able to deal with all these complaints that came forward. It lost all public confidence, it suffered withering criticism in the media, and the gulf between the agency and the public just became enormous. The program at DNR has never attempted to bridge this gap since and have a good, meaningful program between it and the public. Well, because there was no leadership or no protection on the state level, our local governments, our cities, our villages began to draft their own laws regulating oil and gas wells, where they could be placed, the amount of protection they had to have. But in 2004, the oil and gas industry went to our legislature and got it to pass a state law that prohibits all of that funding, or local governments in this state from having any controls on oil and gas wells. We have zoning laws that says, where you can have your industry, where you can have your residential areas, where you have agricultural areas. Those have traditionally been the main determinant of land use in Ohio. Oil and gas was completely cut out of that, and it could go wherever the company filed an application to locate their well. So when fracking began in 2011, this program only had 14 inspectors. At that time, it had 63,000 active vertical wells already to address. And even that tiny under-resourced program was, by law, the exclusive regulator of oil and gas here. Now, with the new production from fracking, permit fees increased, the severance tax got collected, some more staff came in. In 2012, we had doubled it to 30 inspectors. Even with that doubling of inspectors, we were only able to inspect less than 20% of all the producing wells annually. ODNR announced it was going to have to increase the severance tax. The governor proposed it. They said they needed 90 inspectors to properly run the program with fracking. Severance tax increase was thrown out of the legislature, been reintroduced twice since. Each time the industry has blocked it with their friends in our legislature. So currently the severance tax is 20 cents a barrel, and that's one of the lowest in the country. And those resources obviously aren't sufficient to do the job. The program's definitely struggling to make even a pretense of good regulation. In 2014, here's I think an important indicator, the program itself identified 20 areas where it needed to identify regulations, or it had to have regulations to implement existing law. 2014, we need 20 new major regulatory developments. We've only adopted one as of this date. That was done in 2015. Still no public outreach program, and the program is extremely late in providing public records. In the United States, our public records law says the records are the people's, and it's got to be supplied upon request and done so promptly. If you just want 1 or 2 records, you should expect to have that record in 1 or 2 days. So ODNR takes months and months to produce public records. It uses just a simple 2-page application. That's all it requires on production wells, fracking production wells, a 2-page application. It approves those permits in just a week or 2. And we have yet to see a single fracking production well permit denied. We have yet to see a single injection permit denied. I want to spend a little bit of time also talking about the injection well program. It's so important in Ohio. There is a small federal component to injection well regulation in the United States. It comes out of the Federal Safe Drinking Water Act. It was adopted in the 1970s. All injection wells have to meet that law's requirements. And they have 5 different classes of wells, and class 2 wells are the oil and gas waste wells. These are the ones that are of concern to us here. Well, the US EPA first adopted the standard regulatory program, very specific regulations that address permitting requirements, technical requirements, engineering requirements, public participation requirements, a very full standard regulatory program in the American sense. But later, the class 2 oil and gas wells were exempted and had their own program, something called the Section 1425 program, where as long as the US EPA considered any state program effective in regulation, it could be approved and handle its own injection wastes. And no regulations have ever been adopted by US EPA establishing any requirements for this program. The only thing that's done was that a simple and very vague guidance document was adopted by the US EPA when Ronald Reagan was president, 1983, as for this standard. And that guidance document has not been amended in the 35 years since. In addition, Ohio was given authority to do its injection wells on the basis of what's called a simple memorandum of understanding that is 12 pages long. That was adopted also in 1983. That has never been amended since. So injection wells are controlled by a 35-year-old program that's not been improved a bit since, and critically, no improvements were made to it after fracking started in the United States. There is some US EPA oversight, but it is the weakest oversight of any program US EPA oversees. In 2010, the Department of Natural Resources was able to update to the US EPA its program statistics by submitting 1 1/2 pages of information to them. That information did not include the fact anywhere that there were only 3 staff members dedicated to the injection well program in the state of Ohio at that time. US EPA does what they call audits of the program. And when I first got involved with this, I got the 2 most recent audits, 2005 and 2009. They were fairly brief, but what was really sad was that they were not much detail, very vague. And in comparing the two, it became apparent that the 2009 audit was a simple cut and paste tool from the 2005 audits. Over 95% of the wording was identical between the 2005 and the 2009 audits. This is all talked about in reports, and we have links that you can see in the report to get you to that data. So we concluded this whole section on regulatory capture with our history section. We concluded with a section on regulatory capture. I don't know if you have that term where you're from, but in the United States, it means a situation when the government regulator is actually captured by the industry it's supposed to regulate. And the two work hand in hand and keep the public out of the loop. And that's been a great concern of so many of the people who testified at our tribunal. And we have hard documentary proof that has occurred in Ohio. So let me tell you this little story. 2014, we had a public records request to the Department of Natural Resources. And they gave to us about a 15-page document which called a press strategy that had been done by the very highest end of the agency, because press strategy is done right at the top in our agencies. The legislature the year before had passed legislation to allow fracking in our state parks and our state forests. This strategy is how the state was going to, quote, encourage and support that program to allow more fracking into our state forests. And the ODNR listed what it called a group of, quote, allied groups that it would work with cooperatively in this effort. And the people it identified were the Halliburton Corporation, which you may know is one of the key people promoting fracking globally, the Ohio Oil and Gas Alliance, which is the lobbying arm and mouthpiece for Ohio's oil and gas industry, the Natural Gas Alliance, which is the national mouthpiece for the oil and gas industry. So this was the industry itself. They said there would be their allied groups, and they delegated an explicit role to the frackers, and that was to, quote, minimize public concern, unquote, about the practice of fracking. So as revealing as that was, even more revealing is what they said about us on the environmental group side. They described environmental groups as, quote, adversaries. They also called them, quote, eco-left pressure groups. And here's my favorite, quote, zealous environmental activist opponents who are skilled propagandists that would react emotionally and attempt to create public panic over fracking's potential health risks. And as a result of all this propaganda, this press strategy said the state would use a crisis readiness program so that they could respond within hours of any press, any public release of information about problems with fracking in state forests. So this was, to us, proof positive that fracking, that this was a captured regulator, and that they held themselves closely with industry, and they were dead set against not only the environmental groups themselves, but also against anybody who would be opposing the industry out in the field. I think this discussion of regulatory capture was important, and hopefully other states can also cite some concrete evidence like this. It was important because a lot of the testimony at the hearing was about how little the ODNR seemed to concern itself with the public's concerns about fracking. And so you heard a lot of complaining about ODNR. Unless you had some background like this, I don't think the anecdotal information would have the same impact. So now if you would go through the video tapes of the testimony, see person after person talking about the hostility they received from ODNR, I think it's something that will have a little more bite now because of that section. So the next part of our report dealt with the issue of international law. I don't know how things are in your countries, but in ours, very few people study UN conventions and covenants and those types of things. And so we knew we had to let people know what these things were. And it turned out they were quite surprised to hear their situations were addressed by global entities, and that their state governments was falling so far short of meeting those obligations. We did have one problem, and that, of course, is the fact that of all these various conventions, only one of them has ever been ratified by the United States Senate. That was the 1966 Covenant on Civil and Political Rights. That wasn't ratified by the US Senate until 1992. Because of that ratification, the covenant has treaty status. It has some legal significance under American law. But since none of the other covenants, and that would include the Covenant on Economic, Social, and Cultural Rights, and the Environmental Declarations of Stockholm, Rio, and Aarhus, none of them have been approved by the US Senate, so their formal status is rather questionable in this country. I didn't want to spend a lot of time on that, and the way I dealt with that issue, and the way I think is an effective way for other groups to consider it when they're doing their reports. We explain these covenants more in the terms of setting moral and ethical standards set by the global community as a whole. And so we make our case in fracking that our country is not meeting its moral duties, its ethical duties to its people when it fails to meet the standards set by these covenants. This section ends with our stating 10 different rights that we felt were directly affected by fracking in Ohio. So that's the background part of the report that's probably news for a lot of you. And we think that gives context to the testimony. The next section of the report, which is the longest section of the report, just summarizes the testimony, refers folks where they can see the full videotape if they want. Those videotapes also include the cross-examination of the witnesses done by the jurors. We divided the testimony into two parts. First was the testimony on the direct physical effects on fracking on the people who live beside those operations. And the second dealt with the public participation problems of Ohio law. We think that the second item needed to be specifically singled out because on the ground here in Ohio, the state's suppression of fracking information is a major problem. And we think, especially in light of the language of Principle 10 of the Rio Declaration, promoting effective public participation, the Aarhus Convention discussion of governance by disclosure. Since those things were so strong, we wanted to really give focus to that and show the people of Ohio how their government's failing to meet anything close to those requirements. Now, both testimony sections, fracking is a technical area. Research on fracking has been exploding in the last years. Rather than take a lot of time in that, we just cited relevant portions of a document I trust you're familiar with, a compendium of scientific, medical, and media findings demonstrating risks and harms of fracking. This is produced by the Health Professionals of New York, was used to support their moratorium on fracking, also by the physicians' social responsibility. This gets updated, I think, every year. So we put this into evidence, and then really focus from that point on the personal stories rather than on the technical data. The witness statements, I'm not going to go through them in anything specific here. Again, we'll have 3 of them in the second half of our presentation today. But a lot of commonalities came out that I wanted to share with you. I think a lot of these are not going to be very surprising. The main commonality, of course, was how fully the presence of a nearby fracking operation disrupted people's enjoyment of their home and property, caused them great anxiety about the potential impacts on their health. And the testimony was consistent on the following: being impacted by strong and noxious odors, loud, disruptive noises day and night, very strong vibrations of the ground, frequent episodes of burning eyes, burning lungs, frequent episodes of headaches, mental confusion, even tremors, hand tremors, feelings of vertigo, frequent skin rashes, and odd metallic tastes in people's mouths. Also, extremely bright lights night and day. In Youngstown, there's a trailer park of several hundred people right beside a fracking production well. It has very bright lights up on its production towers. That even at midnight at night, at trailer park, it's as bright as the noon sun, night and day. Lots of episodes of people having increases in their blood pressure, which they believe was triggered by stress living in these conditions. A lot about earthquakes. Earthquakes were almost unknown in Ohio before fracking started. Now we have several thousand a year. One of the witness statements will be a geologist that'll give you a lot of detail on that. Earthquakes are particularly happening in the Youngstown, Ohio area in the northeast part of our state. But they also are pretty much everywhere we have fracking. The problem of fires and explosions of fracking sites, compounded by the fact that the emergency responders to these fires have no current information either on what chemicals are on site or where the chemicals are located on the site as they go in to fight those fires. There's also pervasive problems almost everyone testified about. They often have to simply remain indoors and avoid these impacts. They're essentially prisoners in their own homes. The children can't go outside to play. The pets can't even go out. Also, there's the consistent theme about a drop in property values, which a consistent number put forth was about a 60% drop in property values if you're within a couple thousand yards fracking operation. So those are the general and consistent comments people made. But also there were some specific focus presentations on some unique topics. One of them was the impact of fracking on forests. A lot of the southeast part of Ohio where fracking occurs is heavily forested. Our only federal national forest is in that area. It's called the Wayne National Forest. And our US government, particularly under the current administration, is moving very quickly to open up that forest to fracking. Also, a lot of concern about impact on farmland. Farms are down there. A lot of these wells are out in isolated location. Their only neighbors are farms. And a lot of the testimony came from farmers who have to go outside day to day to work their farms when the smell is virtually overpowering. A lot of concern, particularly from organic farmers. Organic farmers in this country are certified with that status. That status is very valuable to them financially. As the air continues to deposit chemicals on their farmland, there's a great deal of concern that they will lose that certification. There's testimony on, of course, climate change impacts and the special dangers of pipelines. Pipelines are crisscrossing our state, and there's a special problem with something called compressor stations. Periodically along a pipeline, there's a turbine that pressurizes the gas in the line to continue to shoot it on its way. There's a lot of air pollution problems that have been associated with these facilities, a lot of bad gas odors, and frankly, a lot of leaks. The second section on testimony addressed the public participation problems. To address those briefly, there is virtually no effective public participation in Ohio. On the fracking production wells, where there's no federal program of any kind, there is no advance notice given to the public that a production well has been applied for at the ODNR. If it was in an urban setting, due to the concerns that came out in the 1970 boom when all the suburban areas of northern Ohio got fracking wells, there's a new category of well in Ohio called an urbanized well, and it depends on how many people around it. Those wells have some advance notice, but all the fracking wells are rural wells, no advance notice. Now for the injection wells, because of the federal overlay, there is some notice. Requires just a newspaper notice that normally appears in the legal notices section of newspapers, which very few people read. Also, it's to be published in a local newspaper of general circulation. A lot of these rural counties don't have many newspapers, so ODNR will pick a paper in the neighboring county, and most of the people in that county actually get a newspaper from the big city 60 miles away. They never have any notice. Fracking well. Even if they have gotten notice, there's a public comment period of only 2 weeks, just 14 days. The DNR will let them make public comment. You can imagine these are very complicated in engineering, how you're going to engineer safely an injection well. Also the geology, particularly in southeastern Ohio, there's very little of a database on geologic information, especially after the first 100 to 200 feet from the surface of the ground. These wells go 9,000 to 12,000 feet down. There is virtually no meaningful geologic data that can be had, let alone something that can be assembled, get your expert together and have comments, just a 2-week period. Also, there's no requirement for public hearings on these wells where people can ask questions. Early on in fracking, DNR had something that they called information meetings. These were something that were their own creation and were very tightly controlled. Normally, public hearings, a person can get up, testify on the record, sometimes have their questions responded to, and the whole audience hear these things. These information meetings, however, there are a dozen different stations at different tables in a large room. People are spread up to go to these different tables and ask individual questions about individual aspects of it. There's no time where the community comes together and can be addressed. Also, the police presence at these information meetings was large and very intimidating. There were even police dogs brought in to one of these information meetings on fracking, the very last one held by ODNR. And ODNR, I mentioned this before, but to give you some detail, they're constantly in violation of the state's public records law. They're required to respond within a reasonable time, and reasonable is to be determined by what's being asked for. Therefore, if you ask for a lot of records, normally the courts say 2 weeks is fine to respond in that time. If it's just 1 or 2 documents, you may have to supply them that day to someone who requests them. DNR typically takes at a minimum of 10 weeks to respond to a public records request. And this is situation where the appeal deadline on an injection well permit are no appeals allowed for production wells. For an injection well permit, you have a 30-day time limit. They don't publish the date of the publication of the injection well permits. So how are you going to find out about it, get a copy of the permit, get it to an attorney so that an appeal can be filed within 30 days, taking 10 weeks to respond to a public records request? I've sued this ODNR at least 4 times now because they were late in responding to records. Every time, the state has admitted to the violation, admitted that it was much too late, and paid the full fine that Ohio law provides. That is $1,000. Whether it's one document or 150 documents, still the same $1,000 fine. And ODNR is happy to pay that slap on the wrist fine rather than go through the ordeal of overhauling its public records program to make it responsive to the public. Well, I see we're kind of getting close to our time, so I'll jump ahead to the report's conclusion section. In our Jurors Aid Recommendations, and it's stated on the very last page of the report. Based on all the testimony, they indeed found that violations of international law guaranteed rights had occurred. They recommended an immediate moratorium on all fracking activities in Ohio till a, quote, full, industry-independent, publicly funded, evidence-led human rights impact assessment has been developed and published in Ohio. And the jurors also found that because the evidence of impacts from fracking is so clear in Ohio and so strong, they urged that such a study be undertaken immediately. Again, we put this report out in December, and no such effort has been undertaken so far. So that concludes my overview of the report and filling you in on what we're dealing with here in the state of Ohio in the USA. I see it's just like 5 minutes till we're done, even with the extra 10 minutes we were given. So if anyone has any questions, I'll be happy to address those, or we can just break for lunch now and get back together at 1 o'clock Pacific time. Any questions?
Rick, if I could jump in, thank you for your presentation and also for the very detailed report, which I have read. It's obvious that a huge amount of effort has gone into that. And I do want to congratulate you on all of the efforts so far. I've got 2 questions, and they are probably related. When I read your report, and what I hear from what you're saying here is that the issue is not only about government enforcement and industry compliance, but there's also seemingly to me a real issue about access to courts and judicial recourse. So why has there not been litigation on this issue, as you said? Is it because people could not access courts? Is it because the laws prevented them actively? Is it because they have little knowledge of judicial processes, no money to litigate, no proper counsel? And this seems to me to be a very serious issue. Since if people had adequate access to adequate judicial recourse, they already would have had an opportunity to voice their concerns in these forums on these matters. My second related question, if I may, is that in South Africa, we know the term state capture very well, although with the previous Jacob Zuma administration, it was closely connected to the issue of corruption, the state being captured by corrupt forces. Now, our courts have played a hugely important role in confronting state capture to the point where it almost overstepped the sacred line of the separation of powers. So it seems to me that the US courts should and could have an equally important role in addressing regulatory capture, especially if one were to assume, as one should, that courts would play an important oversight role in keeping governments to account and making sure that they execute their duties diligently and according to the law. So the question is why haven't the courts stepped up to this important duty? Because they have not been asked to, because they are somehow powerless, which I doubt is the case, because they have not allowed such claims to come before them? Thank you.
Yes, thank you, Louis. You definitely got to the heart of the issue. One of the main problems is what we've talking about a lot here, which is these wells, the offenses against human rights, are occurring in the poorest, most politically vulnerable communities in the state of Ohio. These folks do not have funding to bring in attorneys. First level. Second level, there's only 2 of us attorneys who have brought these cases in Ohio. While there's hundreds and thousands of industry lawyers in Ohio, you can count the number of people who have ever represented an environmental group in Ohio in the fingers of a single hand. But there are legal impediments as well. For production wells, there's a single permit required, and historically, that permit could be appealed to an administrative body called the Ohio Oil and Gas Commission, which has 5 members appointed by the governor who would hear that appeal. Well, at the beginning of the fracking phase, before any of us had really heard about it, in 2010, industry got an initial bill in that talked about well stimulation was authorized. That turned out to be fracking, but they used this comfortable phrase of well stimulation. That bill stripped away the ability to appeal production well permits from the Oil and Gas Commission. Now, I can tell you that the people appointed to these things are as bad as can be. They're political folk. Several people from the industry itself. There's a member of the commission now whose main job is for oil and gas services company. He's the guy who gets their clients. He's the guy who goes out and has dinner with folks and wants them to hire their company. And oh, what a nice calling card to say he's also the person who may have to consider any action brought against them. I brought some actions on oil and gas permits, or rather on injection well permits, lost those on procedural grounds. Big problem here again is we have only 30 days by statute to get that permit appealed to the Oil and Gas Commission. There is no publication of the permit when issued. And even then, half of the permit is considered to be the same type of permit that is liable to be appealed to this Oil and Gas Commission. That determination is what I lost my last appeal on. That parts of the permit, we're going to divide this permit in 2 and say that the parts you're concerned about is not appealable. Our courts, particularly our Ohio Supreme Court, they're very close to industry. You normally look at those administrative tribunals as just a place to make your factual record and take it into the court system, have your errors of law ruled on. Our courts are getting bought up just as bad as our politicians are. So that's the short answer. We're still looking for solutions to that, but a lot more resources have to be made available both to bring legal services to these communities, but also to have a constant watchdog role over this agency to be able to access when these permits are issued. So often I talk to folks and that 30 days is already gone and there's nothing left to be done. That 30 days is a jurisdictional requirement. With that, I think I've exhausted my time, and I'll exhaust my turns if I don't stop.
Thank you.
Thank you, Louis.